All right, everyone, a little bit of a disclaimer. Today's episode's a little different. We're talking about some of the recent Supreme Court decisions and just want you guys to know that while these are personal opinions that may be held by myself and Jordan, they are not the opinions and views of Fisher David as a whole. Just want to give you guys that disclaimer. A little heads up, for this episode.
Ladies and gentlemen of the jury,
have you reached a verdict?
Welcome to the John and Jordan on Justice podcast, your weekly deep dive into personal injury and wrongful death law.
all rise.
Touching on everything torts, legal tech, trying cases to verdict, and the outlandish stories that come with them. And now, here are your hosts, John Fisher and Jordan Reed David.
All right, everybody, welcome back to the show. Another episode of John and Jordan on Justice. We have Jordan here in studio in Atlanta, his home studio, and me here in Florida for, kind of a one-on-one session with just us. No guests today. Talk about...
Yes, and the last episode we'll be releasing on a Sunday. This is
Yeah.
We're going to be switching to a Wednesday release, and actually in anticipation of that, for the listeners out there, we had Ross Guberman come on, who's a legal writing expert out of the D.C. area, and that episode will be released on Wednesday, not Sunday.
Right. So we're here Friday. It's Friday, June 24th. This is going to come out on a Sunday, and I must say, obviously this has been a crazy week, not just as a lawyer, but as an individual in this country. We are witnessing what I feel has been a 50-year journey of which to do away with the decision of Roe v. Wade. And, there was also, I think, 2 or 3 other decisions that also had affects gun rights and also the federal funding for religious charter schools.
Yeah, you grow up, we both grew up in America. You grew up in Virginia. I grew up in New York. But we both found our way to the University of Miami Law School. And, I think back to law school on a week like this and all the precedents and all the opinions that came out that you read from 50 years ago, 30 years ago, 100 years ago. And they just seem, when you read them in those books, black and white, or even off Westlaw, they just seem like settled principles. And then here we are, present day, for me, almost about 10 years into practice, you a little over. And we are currently living in the world where these things are all being turned upside down on their heads and clawed back. So it's an interesting, and for me on a personal level, troubling time to live in, not just as an American citizen, but also, as a father and a husband and a lawyer. I have all these interesting dynamics, and the interplay between them is not, the fallout has not really settled, but nevertheless, we're here. So,
yeah. And I think that as something that needs to be said is elections matter, right? Elections matter. We're in Florida. We also, Jordan, we practice in Georgia as well. But we have seen in our judicial activism in Florida as well, right? DeSantis was elected governor. 3 of the liberal justices had to we have a retirement age, a mandatory retirement age, and they had to get off the bench. So what happened? 3 seats were open. They appoint all I don't want conservative judges. So now there's a 6-1 majority, and we have seen them change the legal standard for experts. They changed the adopting federal summary judgment standards, and we're not talking about they didn't even have a case before them. They're just sua sponte under their rulemaking
power.
Right, which means what is that? Judicial activism. Well,
it's weird. On the one hand, we have to, on the state level, right? The state constitution contemplates that the state Supreme Court should be in charge of its own procedures and rules. And I think, on a core level, obviously that makes sense. But yeah, I think to your larger point is that we're just living in an interesting time. If you were to cabin off the past 2-3 years from today looking back, there's just been tremendous change in the federal and the state landscape, not only in terms of the faces that comprise the highest courts in the state and the country, but also on some of the rules, procedures, and substantive laws that now exist that didn't before, or that used to exist before. And, in the case of Roe v. Wade's, precedential value, it goes to 0 today, right? So it's just a very, very interesting, time in that regard. And, I have long felt, I think one of the a day like today makes me think back to something like one of the first feelings I had in law school, which is these two competing interests where like you don't want the court, any court, to be politicized. It should be like an independent branch, right, of our government. But then this like obvious predictability with how certain rulings of significance will go based on who appointed who, assumptions about political ideology or reading into past concurring or dissenting opinions. And like this idea that you can just I don't want to say easily, but that's the word that comes to mind, so easily predict how a case like the one that was decided today can be predicted based on the composition of the court as opposed to stare decisis, which,
Right.
Really, it's interesting. Stare decisis seems so significant all the time until it just doesn't.
Well,
And,
yeah,
it's
they talk about stare like it, and for those that obviously if they're lawyers or non-lawyers, stare decisis is basically the precedential value of cases decided beforehand, really kind of moving forward and being applied. And what they say is the reasoning behind it is to maintain the integrity of the court, right? That the ebb and flows of the makeup of the court based upon if it's a liberal or a conservative won't affect the individualism of those justices, won't affect the law and the landscape of this country. When you just do away with it, and really there's no other, you can't check them. They're the end all be all. The Supreme Court's the end. There's nothing to be done. So when you look at
short of a constitutional convention put forth by 2/3 of the states, which I don't even want to disregard that as exceedingly impossible as it seems. I mean, that's still at least in theory, something that could happen and maybe will happen. Who knows? One day in our lifetime.
Well, I think the problem with 66%, well, right now we have 39% of states who have effectively banned abortion.
Right.
There you go. There's your answer. We'll never reach that threshold. I mean, and we were just talking about this off camera. The Missouri Attorney General just came on and said, we are proud based upon our law, because it had an automatic trigger in the event this law is reversed, because this is something that's been brewing for years, that he was proud that they are the first state to eliminate abortion without exception. Without exception.
Yeah, I think, and I haven't done the deep dive, but I think it's because there were some old carryover laws from pre-Roe v. Wade, and now if Roe v. Wade ceases to exist, then those laws theoretically come back into play. But yeah, it's kind of, I don't know, it's unsettling for me, both as a lawyer and a human being.
Yeah.
But when I've read as much as I can, it's a long opinion and probably one that should be read 8 to 10 times before you pretending that you really understand what the court is trying to convey. But at the end of the day, what's the name of this? Is it the Dobbs opinion? Is that what it's going to kind of be referred to? Dobbs versus Jackson?
Yeah.
At the end of the day, it's one of these things where, although we're talking about is there a right to an abortion, it really comes down to substantive due process under the 14th Amendment,
Right.
Whether or not there's this inherent right to privacy there or other rights. And, even though the majority opinion authored by Justice Alito has some express carve-out language that we are only addressing the right to abortion, this doesn't impact any of our prior precedents on any other constitutional rights. Then you've got Justice Thomas in a concurring opinion, and Justice Thomas obviously having joined the majority, basically saying, well, we should call into question some of those other opinions. And I think, for those out there that haven't made the connection, the reason Justice Thomas is saying that about things like same-sex marriage and other things is because those rulings upholding the existence of those rights were based on the same substantive idea that the 14th Amendment afforded these things. And so if it doesn't afford abortion, it's, yes, we can read this opinion narrowly, but it's also like a head scratcher to think that when these other rights get challenged, and I'm sure there'll be a wave of litigation about it, how's the majority of the court going to distinguish it at all? Abortion to same-sex marriage. They're two different things, but in a legal sense, they both arise, or they used to, out of the same area of law, out of the same portion of our Constitution. And now it seems for one of them they don't. So it's just I don't know if the writing is on the wall is the right expression, but getting back to this idea of like being able to kind of predict how future legal challenges will come out. We're trial lawyers predominantly. Nobody really knows how a trial is going to come out. You have educated guesses, but you never really know because it's in the hands of jurors who are people of the community. On the appellate side, especially when you get to the higher courts, you have this weird sense where you can almost predict. And so we'll see when and if that happens, but that's what my intuition says.
Yeah, I mean, I think Judge Thomas in his concurring opinion, used the words "decidedly erroneous." I think was when he talked about 3 Supreme Court opinions. One was Lawrence, Offerdahl. I think it's not, might not be Offerdahl, but it starts with OF, and then I forget the third one. But the idea was that the access to contraceptives for a married couple was one of them, which seems to me like that shouldn't even be an issue, but I guess it is. The other one was Lawrence. That was the one where essentially the ability to have or perform sexual acts in your home, which was really derived.
Again, a right to privacy, right? Like at the end of the day, it's right to privacy.
And then the other one, and I guess that was in a predominantly same-sex relationship. That was, and then they had the same-sex entitlement to marriage. He said these are decidedly erroneous. They're based on the same due process rights, and that Roe v. Wade was, and that it should be revisited and basically overturned. And I talked about this is because there was one opinion that he did not mention was Virginia versus Loving, or if it's Loving versus Virginia, which was the entitlement to individuals to have interracial marriage, right? I think it was a white man married a black female, or a black female married a white male. And he didn't mention that case, which again is based upon that same reasoning, and that's because Clarence Thomas is a black man married to a white woman, right?
Well, I'm a white man married to a black woman, and I mean it's uniquely in my consciousness, and I'm sure tons of others.
Yeah.
And it begs the question. This is what I was suggesting to you earlier, and your point is a valid one. We're talking about abortion today because that's the decision of today. But at the end of the day, if you just peel back one layer, it really calls into question, is there even a limiting principle if we're going to say that the 14th Amendment doesn't have this inherent right to privacy? So I'm just pulling up, I think it's page 5 of, it's not in a reporter yet, but of the Dobbs decision. And you've got the majority says this: Roe's defenders characterized the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. Doesn't say gay or interracial, just marriage. But abortion is fundamentally different. I basically quoted, except for my little editorializing over marriage. So you've got the majority basically saying, oh, no, abortion is fundamentally different. But as far as I can read the opinion, I don't know how substantively that can be said. If all of those other areas of law, those rights, I'm going to call them rights because I believe that they are, and as of today they are. If those rights all arise or stand on the same foundation, and today a majority of the court just said that foundation is not even a thing. It was never a thing. It was erroneous from day one. Well, then how on earth can you say abortion is fundamentally different? And I don't, if I were a betting man, which I am, but not in this context. I mean, just casually, if I were a betting man, I find it impossible to believe that when these challenges find their way up, that the court's going to be able to meaningfully distinguish them on some fundamental difference. I just don't see it. And it's, for me, like I said, as a human being and as a lawyer and as an American and all these things, and everybody's entitled to their own opinions, and that includes me. It's incredibly disheartening and disappointing, and I have these feelings of fear that I really didn't have before. As the father of 2 young children, as the husband of a black woman in an interracial marriage, all of these things come to my mind. Just like, where's the limiting principle here?
Right.
And it's hard to feel the love in a moment like this, and I'm not trying to be self-involved, but everyone out there has to kind of reconcile these things on an individual basis, right?
It's okay to be self-involved. I mean, these opinions are wide sweeping and affect everyone, right? People use the word slippery slope, right? You always you got to think about, what is this going to do? Is it going to create a slippery slope? It's been created. I mean, this opinion can be applied to run downhill and smash through all those other Supreme Court opinions. Because if you're going to say that this legal application, which upheld Roe v. Wade, is erroneous, then that same application, and it doesn't matter in what context, right? Because I don't think if you're saying that there's some kind of factual dissimilarities between it, there's really not. It's really the legal basis to find that protection afforded in the Constitution. And if that legal basis is wrong, and it's the same basis for a multitude of opinions, the Supreme Court said it's wrong.
Yeah, I mean, they don't just say it's wrong. I mean, here's page 6 of the opinion. This is one sentence. Roe was egregiously wrong from the start. Period. End quote.
Yeah.
Those are pretty strong words in any appellate opinion, let alone from our nation's highest court, talking about precedent that's been there for 50 years, talking about a precedent. It's not just like Roe v. Wade exists in a vacuum, right? We had Casey versus Planned Parenthood many years later, modifying the doctrine a little bit, but ultimately affirming the underlying principle. So, for a court today in 2022 to say a case was egregiously decided way back then, but another version of this court not too long ago relative to our history affirmed it. It's just, I don't know, it's a bit of a head scratcher. It's not that the writing wasn't on the wall or that, this is a situation where, I mean, in a truly unique situation where there was like leaked opinions of the leaked draft opinions. So the writing really was on the wall. I don't think it took anyone as a surprise, but it takes me by surprise in terms of the reasoning. Just complete evisceration of something that had been there for a long time and used in a variety of contexts to uphold what I'm going to continue to call a right. And so, I mean, it's kind of beyond the scope of this podcast, what's intended, but I mean, my heart goes out to anybody who this opinion changed their life on an individual level or family level today, literally today. Massive changes, or massive hurdles put in someone's way. It's just crazy to me. I don't know. It's
I mean, look, we
unfortunate.
We're a legal podcast that talks about legal effects, but when big Supreme Court decisions come out, it affects all of us. It's important to talk about, right? Because the benefit of having a supposed free working society is communication and dialogue and speaking up and protests and all of those things. I mean, that's what's supposed to be fundamentally a backbone of this country, right?
Right.
One thing, and for the listeners that aren't here, we have Justin who helps us out with information, so I'm going to ask him to pull something up. Can you pull up for me the confirmation vote for Ruth Bader Ginsburg? Just a number real quick, and I'll talk. Just pull it up for me, and I'll get to my next point. The reason why we think that these courts are politicized is because I remember, you had these individuals when they were confirmed, it was overwhelmingly confirmation on both sides. Ruth Bader Ginsburg's confirmation vote was 96-3.
Right.
96-3.
I think she wrote, by the way, Casey, I'm pretty sure.
Right.
That intervening between Roe and the Dobbs opinion today, there was Casey versus Planned Parenthood. I think she wrote that.
Yeah. Did she argue Roe? I don't know if she argued Roe before she joined the bench, but So you have this idea that, look, Ruth Bader Ginsburg was appointed by Clinton. She was a liberal judge, but she was afforded the respect of nearly entirety of the Senate. All of the justices, the last three, was 51-49. I may be mistaken, but I think that's my recollection of it. It was something like that. Gorsuch, Kavanaugh, Barrett. And at their confirmation hearings, they specifically were asked about Roe v. Wade. And they were like, look, this is settled law. It's the law. That's what it is. And then here they are just ripping it and saying it's actually not good law. Goodbye. So it's like, why do we even have confirmations here? They're never going to tell you how they're really going to feel. Right? They're going to say
there's so many imperfections in what is objectively, I think, verifiably one of the best ways to approach governing a country. And that particular process you're talking about is one of them. And I don't know how you fix it. But, when I when I think about judicial decisions, days like today, reading opinions like this, complete reversals, it really, in my mind, stokes those flames. I'll just put on my tinfoil hat for a minute. But I mean, it's is the law going, is the citizenry more likely to benefit 10, 20, 50 years from now from more of an artificially intelligent, less human application of judicial decision making. Because if statutes are what they say, we read the text, and judicial decisions should have precedential value, then what? I mean, it's just so hard to believe, right, that a majority of the same body, the same court body, 50 years ago can say one thing, reaffirm it, then extend it in other contexts, same-sex marriage or whatever. And then just because political winds change, now it's like a complete reversal. It's like, it just shouldn't, you should have more. I don't want to keep saying stare decisis, but it should mean more than that, right? It just really should. Once it's settled, it should be settled. And I just feel like the human element has a way of interrupting, interfering, and meddling, oftentimes maybe where it shouldn't, where things are better off left.
I think individualism has taken a huge place over community in many aspects, but in terms of the application of the laws, like the law should be the law, right? And then to come in 50 years later, I mean, look, when Roe was decided, 1973, I looked this up. One of the top songs was "Tie a Yellow Ribbon Round the Old Oak Tree." That was one of the number one songs.
I'll confess, I haven't heard that one.
Yeah, by Dawn featuring Tony Orlando. I mean, we're going back it's just, I don't know. We go back to the time that illegal abortions, people that are products of rape and incest, and yes, these are very extreme things, but for me personally, probably on the individual minor scale of my life, I'm not going to be affected. Right. But there are those individuals that may be. And as we talk about where do we draw the line? Where do we stop? We see individual
John,
liberties.
You're a parent. A parent, we don't know where this goes for our children. And, so that anything that affects our children would affect us. I don't know. I don't think any of us really know how it's going, the true reach. I just think all of us, well, you and I, on a personal opinion level, just feel like it's a change for the worse. It's a shifting in course the complete wrong way, and it's unfortunate. And I don't really care beyond that. It's just
I just think it's going to lead to what we already are, which is a tribal society. You're either on this team or the other team. Good guys or bad guys. Whoever side you're on, that's what it's going to be. There is no, common ground. Who is it? The justice. I don't know if you were at University of Miami when I was there. Who was the Supreme Court justice just had retired who had came to speak? Were you there when he came?
Well, John Paul Stevens, I know, had come a couple of times.
That's who came.
I don't think he had just retired. I don't know, but yeah, I think he lived in South Florida.
Yeah, no, I think it was recent when he had left the bench, but he came down and I remember giving a speech, and I feel like he's one of the last true moderates that was on the court, right? Look, you do a lot more appellate work than I do, but I think he's one of the last true moderates. I even think, I think Gorsuch and Kavanaugh are more moderate than Alito and Thomas, right? Some of the older, those guys, they're on the other side. And obviously the same can be said about Sotomayor and Kagan, but, there needs to be commonality, right? Like we as litigants, we're trial lawyers. We're against the defense. We're against, the insurance companies.
We're for people, man. That's the thing. We're for people at the end of the day on a very individual level. Every single day we wake up, we're representing individual human beings. I don't care what anybody else does for a living, and I pass no judgments, including the people we often find ourselves going up against, so to speak. But at the end of the day, we're for people. So it should come as no surprise that when there's an overarching huge decision on a constitutional level, on a national level, that, in my opinion, is not pro people. It doesn't sit well, Yeah. It just doesn't sit well with me. It's just
right. But what the point I was trying to make was simply that there has to be some sort of commonality or working together. There has to be, even that we're against our adversaries. Now, a lot of times there isn't, but we always have this. And I don't know if it's true. Maybe it's bullshit. We hear labor seek the truth. Right? You see that in every courtroom. It's all said that we hear, and it's almost like we're supposed to be working together, but that doesn't happen a lot of the times. It should, right? I shouldn't be arguing the same thing in the same position in every single case, time and time and time and time again, but it happens. And so maybe that's just a reflection of who we are as a society now. We don't work together. We don't get along. We don't try to find common ground. It's like you're either on my team or you're on the other
Well, I
team.
think many issues are, it seems like more divisive than they were when I was young, paying attention as best I could. But again, that's a matter of perspective. I could be wrong. And I also think humans have a general tendency to think that what they're going through, what they're living through in any given moment is of more historical significance than something that's happened in the past.
True.
I just think that's natural. And I don't think, like I said, there's anything wrong with that. I just think it's like the natural human tendency. But this is obviously 50 years getting turned on its head, and really more than that, because how long did it take for Roe v. Wade to finally find its way up there and get decided in a favorable way in terms of finding a right?
Yeah, and what I always think about what are these like groups of people that get together to like file lawsuits? Like these, they're almost like super PACs I think of that are just like people for the ability to control and have guns at all times for the people. Like some weird name, long, like lengthy. I'm in this club and I have standing, and and they are able to bring these lawsuits.
Yeah, they're just pushing issues. I mean,
Right.
there's professionals that do that, and I think there's value to it, and I think a core level, right? I mean, important issues should be teed up, I think, set up the right way so that a fair disposition of them can occur. And sometimes, like when it gets lost in the trenches, it can get muddied and not really give the best vehicle to make an important decision. So I don't think there's anything wrong with it generally, but yeah, you're right to say that it seems like there's like a never ending machine constantly litigating these big issues until they find a win on their side,
Right.
I don't know how you stop that. I don't think you can realistically expect to stop it.
Well, I think what you say is until the makeup of the court is what you want, right? You keep bringing the issue, and then eventually what
seems that
happens?
way.
I think that I want to say one of the, I don't know if it was the opening of the dissent where they say that, I'm going to misquote it, but they talked about saying that talking about specifically the makeup of the court in their opening of their dissent, right? Of like, that's what the only thing that has changed since Roe v. Wade and Casey versus Planned Parenthood is the makeup of the court. That's it. And so but it leads me to another thing to even talk about is like, but the problem is that they're like, look, it's not the court's job. Like if they wanted this if they're going to say, look, it's not in the Constitution, or if it is, this could have been codified, right? It could have been made a law at the federal level. And I think that Jimmy Carter had an opportunity, Obama, Clinton, and I think even Biden right now, and none of them are doing it. And none of them had done it, And I saw somebody post something that kind of made sense, is that sometimes it's almost like, the Democrats need a wedge issue like this to like I don't know if it's not hinge an election, but make it an issue, and then they get in there and they don't do anything, right? And so
Yeah.
it's frustrating.
I mean, we're going to
It's
see,
just- yeah,
right?
it's-
Everything before today, when this opinion was released, even though we had the draft opinion, so the writing was on the wall, everything before today was speculation and what would happen. Now we have to live in this post Dobbs decision. So we'll see who kind of steps up on a legislative or executive level or whatever, state, federal, and we'll just have to see how it shakes out, because really at the end of the day, Dobbs it's now the law of the land.
Yeah.
Period. End of story. It's like, I don't want to say end of story, period. For that case, this issue, that's the end. So unless there's some change on another level, the judicial system has put a period to end it. And, I find, separately, I don't want to talk out of school again. I'll confess I haven't read the New York Rifle and Pistol Association, whatever it was, decision that came out. Was it yesterday or the day before, earlier this week?
Either yesterday or the day
I haven't
before.
finished reading that, 130 something pages, and I want to do that on a couple of occasions just so I better understand it. But the timing of these two pretty monumental decisions is it's probably compounding the effects of each of them individually on me as a lawyer and a person. Because on the one hand, you've got basically a court saying, I mean, this is just ultra dilution probably, or distillation rather, but in the abortion context, there is no such thing as a right to it. So leave it to the states. Just leave it to the states. And then the other side, when it comes to basically possessing a handgun outside of your home, Well, I mean, we can't really truly leave that to the states. If the states want to regulate that or put limits on that, we really need to force them to justify it. It's just this, and I know one is the Second Amendment. There's a textual reference to firearms. I'm not going to get into my personal interpretation of it, but I understand there is some difference between the two. But just the timing between the two, their overarching approach. Leave it to the states. Don't leave it to the states too much. I don't know. It's hard to wrap my head around in this particular moment.
Yeah, I mean, and for the benefit of the listeners, I mean, look, we're here talking about very important issues that aren't just about.
You think we'll have listeners at this point in the podcast? So just turns it off. Click.
Maybe, and if they do, I mean, listen, everyone's free to close their ears, but what they shouldn't do is, one of the things that I learned is to open your ears, to listen to other viewpoints. And, I try to consider the opposite side of the argument if I can, because if you're closed-minded, you're never going to see the ability to see the other side, right? When we had Dave was down here talking about, it's not about being sympathetic, but being empathetic. Like, you have to see how this affects other people, right? Not that it's my personal belief that it's wrong, so therefore I win. Yes. Well, look at the other side of it. You could say that, somebody could have, you have a non-viable child that's not going to live. You need to carry it full term. Do you think people just think that people are picking up abortions at Walmart through an express drive-through? This is a very hard decision that people make. It's not something that's easy. A lot of times the people that are getting the abortion already have kids. And if it's not situational, if you just categorically say, know what, then what's going to happen? You're going to see people leave those states.
Yeah, I mean, I hope so. I hope that most states post Dobbs enact or modify their legislation to be to kind of get as close as we can to where it was before for the constituents of those states and neighboring states, probably. But I mean, I don't know. It's all kinds of interesting things about
it's just, it's like a Friday. Shit's hitting the wall. We're hitting. I don't know, man. I just think it's such a weird. I don't know. We're lawyers. Every time I get myself to this place in this rabbit hole, even well before today, I always stop and I'm like, don't go any further, because it's just such a weird thing that at the end of the day we're construing this. It's far from ancient, but for our country, this document, this incredible document, brilliant document by these brilliant people, but really we're just stuck construing it, putting it through the wood chipper all the time to find meanings, and it's going back these historical interpretations. There's a quote in that gun case, the New York State Rifle and Pistol Association. Let me see if I can find it. Hold on, because I was here. I don't know. This isn't a quote, but I mean the general idea was we always have to go back and look at historical meaning and context, always. But when it comes to the Constitution, I mean, some history matters more than other. It's just, I don't know. It's this really hard, arbitrary magic 8 ball. What did they mean? What really mattered? It's just crazy. I don't know. It's crazy what we do, what we have to do, what courts have to do. It's just very, very interesting. Yeah, I mean, look, it's a hard job. On every issue, there's going to be one side that's happy, and one side that's not. On the side of every trial, there's going to be one side that's happy, one side that's not. I mean, that's our legal system. There's a winner and a loser, right? That's the way it works. I mean, that's
yeah. And then as well there should be. I guess if I had one general feeling that's feathered throughout, it's just it just bothers me on some fundamental level. I think mostly as a lawyer that huge issues of constitutional significance can shift based on basically the composition of the court and the changing political landscape.
Right.
I think that's what bothers me. It's if it's supposed to be independent and the Constitution is the Constitution, that's it, supreme law of the land. I just feel like those things, it's not that anything is fixed in stone, and I'm not one of these advocates that once decided stand forever no matter how bad. I get it. There should be exceptions to every rule, including stare decisis. It just feels forced in this example. Do you know what I mean? Yeah. Jamming it through as best you could, and then here we go. Predictably, it happens, and I don't know. So
yeah, I mean, look, justice should, really should be non-political and unbiased. It really should, but remember.
And also, equality shouldn't be a liberal concept, whatever that means.
Well, remember, in a Time to Kill, right, the movie Matthew McConaughey, 1995, and he talked about whether he could get a fair trial for a black man in Mississippi, right? That was the big issue. And I remember the judge was like, you made a really good point, and I agreed that a black man can't get a fair trial anywhere in Mississippi, so might as well be here in the county where he's at.
Yeah, I remember that.
He was like, I agree with you. And he kind of was like, look, we as human beings, like the law is directed at human beings, and human beings aren't perfect, right? We're not, this ideal world where law is unbiased and people don't, like, they leave their, baggage or who they are beside. We know they don't do that in juries, right? That's why we move to exclude them and talk to them, because they're a product of their own background. And the same is for judges. We can try to be as, they can probably try to be as, like, independent and unbiased they can, but we're still humans. So, and we don't live in that.
Nobody is unbiased, and nobody is independent. I refuse to believe either of those two things are true. They're aspirational, and I think we should all aspire to be that in the law. Like, especially, from the bench. I mean, when we're advocates, we're not, but we're biased for our clients, and we're trying to win. But I mean, I don't think anybody can reach that point. I think it's an ideal that can never be reached, which is fine. That's a reality of life. But I don't know. There might be some interesting other solutions. When I say solutions, I just mean bigger picture. So things overarching, like lifetime appointments. Just a weird concept.
Maybe they shouldn't be anymore. Maybe
just a weird concept. I think.
Well, it's that actually might not be a bad idea. I mean, look, we talked about, like, term limits for people in political office. That should be a thing. I'm okay with that. Why should it be any different for judges? Why should judges think that I'm just here forever? Because, like, the law and society changes. It's almost like you need fresh thought, fresh idea, fresh blood in there at a certain amount of time. Maybe it should be 20 years. You can be 20 years on the federal bench, 20 years on the Supreme Court, maybe less. Right?
Anything less than lifetime appointment would be a start. Because
they can do whatever they want.
It's just an interesting concept, because it really gives, perhaps, I mean, this is a theoretical or a philosophical discussion, but I think it gives people the reassurance that give me enough time, I'll be able to kind of have my personal view materialized and memorialized in potentially binding law for a jurisdiction, or in this case the country. It's just an interesting thing, as opposed to if I'm here for 10 years, 20 years, I'm going to adjudicate the issues that come before me, and some of the issues that may matter to me personally may never ever come before me during my tenure, and that's just fine, because I'm not here to be an activist, right? But I think when you have a lifetime appointment, it just grossly increases the odds that somebody's personal opinions or personal perspective is going to end up eventually being memorialized into law. It's just
and I think it would help with the integrity of the court, right? If it's not just because everyone's going to look at this like this is a completely political opinion. And I used to say that Justice Roberts, when he wrote for the majority in the Affordable Care Act decision that upheld it, that he did that because he did not want a political court. Well, too bad, too sad, because that's all he's got now. That opinion doesn't even matter. Well, it's a tax. I upheld it. Great.
Not having a political court in the landscape we live in.
Correct.
Back to my point. It's not even. It's like
it's
an
not
ideal,
a thing,
and it's a good thing to aspire to. And I've never clerked for any judge. Let alone the United States Supreme Court. And so, I mean, these people are brilliant, far smarter than I'll ever be. And I'm sure, John Roberts is doing his absolute best to get some uniformity among the court, to make it seem less political and all that. But I'm just saying, at the end of the day, we're living with the decisions that come out of it, and the timing of when they come, and who's writing them, and the words that they use. And so we're doing our best to decipher them and interpret them. And it just feels, individually, I think, for you and I, a bit more political than legal,
It's 100. Well, I mean, come on. I mean, you don't have three justices that get in when they tried to block Obama's appointment, and then you get another seat, and then you jam in one 18 days before an election, Judge Barrett. I mean, it's all political. I mean, the makeup of the court is political. The fact that they were in if they were 51-49 or along party lines makes it political. That's all it is. It's just a political court. They're not. It doesn't matter about decisions or other ideals. It's like, look, you got put in by your party, follow the party. That's what we want.
Yeah, I'm just saying, for a country that's its very founding was premised on freedom, which it is, and I think it's the greatest country on earth, and I am proud as hell to be an American. There's a lot of people in positions of influence, I'll say, they care an awful lot about how other people live their life.
Yeah.
Meaning like that it's not entirely free. It's just like these are competing principles to me. Well, I don't know. It's just it's hard to swallow.
It's interesting you say that, because I think it's not about same-sex marriage. It's not about same-sex acts or abortion, or it's about control. Like you said, people want the ability to control what others do, and I don't care what people do in their own life, right?
Well, especially in their own private life. I think,
like it's
there's a limiting principle on everything. I think we could start at like privacy of your own home, within your own marriage. Who you choose to love, have relations with, whether or not you choose to bring a child into this world. These things are highly personal, highly private, highly individual decisions, in my personal opinion.
Right.
But we've got an awful lot of people out there of influence who will stop at nothing to exercise some degree of control. It just it seems antithetical to what America is. It has long felt like that for me. I've got people in my family who are homosexual and married. I myself am in an interracial marriage. I've met many, many people in my life. I hope to meet many, many more from all different walks and facets, and things matter different to individuals. I just think, like, can we not all get on the same page that within someone's home and privacy, those things, let them decide on their own?
Are you a good, like, they're good people. People are good people, whether what they do or what they like. I mean, we've heard a lot of stuff coming out of Washington about some of the things that they like, which should be looked upon disfavorably. But you know what? No one cares. Like they this idea of like, yes, we won. What'd you win? Doesn't affect you. It didn't affect you before. It's not going to affect you after. What did you win? Like I don't understand it. And to me as a lawyer and individual, I mean, look, obviously, I think by my verbiage and what I'm talking about, obviously people can see where I fall. And I don't want to say I'm like one side versus the other, but I am more predominantly on some issues. I would associate liberal, not progressive. But the idea that if you're protecting child rights, then you need to protect them outside the womb as well. And I just don't see. I see it unified against that. So then what? So it's not really about the kids. It's not really about protecting the baby. It's about control. That's how I feel. Because if you really felt that way, you would say, let's protect them inside, outside, and otherwise. And so if they need financial assistance from the state, we can provide that for them. If they need health care, we can provide that for them. And I always felt, how we to really, if you want to determine the success of a nation and their how developed and how successful they are, it's how we take care of our people, right? We don't give paid time off. We don't give paid maternity leave. And we own a business, right? We do these things because it's like the decent thing to do. Don't have to do it. Don't have to give paid time off. Don't even have to give paid holidays. Like we can't require them to work, but we don't have to pay them. So there's this idea that, who are we protecting? Because if it's about the individual and about the people, we should be protecting us. And when you start eroding individual liberties, right? They start to erode. I mean, we've lost liberties for the illusion of safety, right? We are being recorded on our phones, whether you want it to a national and NSA and all these things. Everything we talk about is used, discussed. That's why you can talk about something and then
we both have our tinfoil hats on today for this episode. I didn't know.
No, but I'm just saying, like, come on, you haven't been there talking with somebody, and then you're like, oh man, I really want those pots.
I didn't say I disagree with you.
And then
I was just making sure the audience knew.
Yeah, you have
we're
a targeted
tinfoil hats today.
Yeah, you've got a targeted Facebook ad about those Caraway pots that I just talked about to someone in a different room. It wasn't even my phone. Like, and look, it's crazy. And I just think that if we get back to our core as individuals, is like, look, we are the important ones, right? And so we have to protect ourselves as our individualism as the people in all aspects, not trusting a few, influential people to do what they think is best on our behalf.
Yeah, I wonder how, assuming things stay the same, which is not a safe assumption, but let's pretend in the hypothetical things stay the same. I wonder, today is a day that makes me wonder what law students 100 years from now, reading their textbooks or whatever the hell the medium is going to be then, that they get their information. and they look back on this period, like how we in law school would like learn about the Lochner era, the whatever was the 20s and all this stuff. Like, you look back on it, it's historical. There's some gloss on it. People have had time to digest it, but I just wonder what they're going to say about this period of time. Like why, are people just, why the hell did they care so much about what people did in privacy of their own homes? You know what I mean? Like, is that, or will it be the other way? Like, will it have gone so far that this will seem like, I find it hard to believe that there were ever rights read into the Constitution for these kinds of things. That's unbelievable. I don't know.
Could be. I'll be long in a hole in the dirt before that happens. So
you and me both, pal. But I can still wonder. Look, one of the objectives of this podcast is to share the views of John and I. And when one, let alone two, monumental Supreme Court decisions come out, we're not going to we're not going to ignore them. So we appreciate those of you that have listened throughout. And we hope, everybody enjoys their weekend. Reminder, we're switching to a Wednesday release with our first guest being Ross Guberman, who teaches basically federal judges on down how to write effectively. That's a really good one. So we're kind of shifting back to a normal programming. And we've got some really interesting guests even coming up after Ross, talking about jury selection and the data and analytics side of that. So we look forward to it. But for now, that's it. Over and out. Everybody have a great weekend.
All right. See you guys.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter. Or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.